Good afternoon, everyone, and welcome to the Gaines Center's webinar, Implementing MAT in Drug Court Settings. I am Melissa Neal, a Senior Research Associate at Policy Research Associates and the lead for communications coming out of SAMHSA's Gaines Center. And I have just a couple of housekeeping remarks. First, the views, opinions, and content expressed in this presentation do not necessarily reflect the views, opinions, or policies of the Substance Abuse and Mental Health Services Administration or the U.S. Department of Health and Human Services. At any time during the presentations, we welcome you to submit your questions. On the right side of your screen, you should see a Q&A pod. You can click that, and within the pod, enter in as many questions as you like. We do collect questions throughout the presentations, and we will wait to answer them at the conclusion of the last presentation. If you do have questions for specific presenters, perhaps make that clear in your question. You'll also see on the right side of your screen that a poll has popped up. We'd just like to know who is joining us today, who we're speaking to, what agencies and areas of the country you may be joining us from. So if you would participate in that poll, we'd greatly appreciate it. This webinar is being recorded, and we will disseminate slides for this webinar via our Gaines listserv in the days following this webinar. We also will distribute the URL link for the webinar recording once it's approved for distribution. At the conclusion of the webinar, we do provide a certificate of attendance. We do not provide CEU credits, but if you are able to use it for personal credits, then you are welcome to download the certificate of attendance for your personal use. Just a quick look at our agenda. We're excited to have John Berg from SAMHSA providing some opening remarks, and then we have 3 presentations from national experts and people who are working at state and local levels, implementing MAT within drug court settings. But first, I'd like to turn it over to John Berg at SAMHSA for some opening remarks. John?
Thank you, Dr. Neal. Welcome to today's webinar, Implementing Medication-Assisted Treatment in Drug Court Settings. We appreciate you taking time today to participate in today's informative webinar. SAMHSA is interested in promoting medication-assisted treatment in drug court settings. There is overwhelming evidence that medication-assisted treatment is an effective intervention for addressing opioid use disorders in criminal justice populations. We believe that MAT is an important part of a comprehensive treatment plan. Through our funding opportunity announcements for drug courts, we encourage drug court applicants to use up to 35% of their annual funding award for Food and Drug Administration approved medications for MAT. MAT is an evidence-based substance use disorder treatment protocol for alcohol and opioid use disorders, and SAMHSA supports the right of individuals to have access to FDA-approved medications. SAMHSA does recognize that not all communities have access to MAT due to a lack of providers who are able to prescribe and oversee clients using anti-alcohol and opioid medications. Our focus today is to present justification and support for implementing MAT in drug court settings and information on how to implement MAT effectively in these settings. SAMHSA recently released an evidence-based resource guide titled Use of Medication-Assisted Treatment for Opioid Use Disorder in Criminal Justice Settings. This guide focuses on using medication-assisted treatment for opioid use disorder in jails and prisons and during the reentry process when justice-involved persons return to the community. It provides an overview of policies and evidence-based practices that reduce the risk of overdose and relapse. Another resource provided today is a recently released SAMHSA document entitled Medication-Assisted Treatment in Criminal Justice System, Brief Guidance to the States. This brief provides guidance to state governments on increasing the availability of evidence-based medication-assisted treatment in criminal justice settings. Both documents are provided today as a resource and can be found on the SAMHSA website. We are excited to host today's webinar. Today's presenters will provide professional expertise and share personal insights on how to implement and manage effective MAT programs in drug court settings. They will share about some of the challenges they have faced and lessons learned along the way. We are pleased to have 3 experts in the field present today: Associate Commissioner Hansen, Commissioner Woodiest, and Dr. Doug Marlowe, who was the lead expert serving on the expert panel for the recently released document on use of MAT for opioid use disorder in criminal justice settings. I would also like to thank the Gain Center and their staff for their work in developing and facilitating today's webinar. At this time, I will turn it back to Dr. Neal.
Thank you so much, John. All right, now, so just a little bit about our presenters today. Dr. Marlowe is joining us, and he is a senior scientific consultant for the National Association of Drug Court Professionals. He's a senior science and policy advisor for alcohol monitoring systems, and he's a training consultant for the Global Institute for Forensic Research. He has published over 175 journal articles, monographs, books, and chapters on the topics of correctional rehabilitation, forensic psychology, and treatment of substance use disorders. He also serves as the editor-in-chief of the Journal for Advancing Justice. He's on the editorial board of Criminal Justice and Behavior and was previously editor-in-chief of the Drug Court Review. Rochelle Woodiest was commissioned to the St. Louis City's Adult Treatment Court in 2013, and she has presided over adult drug court, family, and juvenile courts. Currently, she presides over the adult court, serving individuals that are assessed to be in all quadrants of risk and need. She, in 2017, was recommissioned as the Treatment Court Commissioner. And Steve Hansen is the Associate Commissioner for Courts and Criminal Justice for the New York State Office of Alcoholism and Substance Abuse Services. Previously, he served as the Associate Commissioner for Treatment, overseeing treatment services in New York, including direct oversight of 12 state-operated inpatient treatment programs. And he is on the faculty for the National Drug Court Institute. He has done that since 2001. And now just a quick look at our poll. We see that many of you are joining from rural jurisdictions, followed by a group of you from urban, and then lastly we have a few of you coming in from suburban jurisdictions. And we're excited that many of you are joining from judiciary type positions. We're also seeing a number of people joining from probation and parole, public health, government, and community-based services. So thank you so much to you all for joining us today. I will now turn it over to Dr. Marlowe.
Thank you, Melissa and John. Thank you all for joining us for this webinar. This is an incredibly important topic. We have very good reason to believe that medication-assisted treatment is grossly underutilized in the criminal justice system. Some of our best estimates is that at most about 10% of people with opioid use disorders are receiving this evidence-based treatment in jails, prisons, probation, and parole. And our best estimates is that about half of drug courts in the United States are either prohibiting the use of medication-assisted treatment or requiring individuals to taper off certain medications within arbitrary time limits. Medication-assisted treatment is the standard of care for treating opioid use disorders according to the organizations listed on the slide in front of you, and actually many other organizations as well, but I ran out of space on the slide. The Department of Health and Human Services, National Institute of Drug Abuse, the Surgeon General, SAMHSA, National Academy of Sciences, World Health Organization, the CDC, and on and on and on. These organizations have official statements that the use of medication-assisted treatment is the standard of care for treating opioid use disorders, and this includes the National Association of Drug Court Professionals. Now, another word for operating below the standard of care is malpractice, and there is good reason to think that there may be many programs out there treating people in the midst of an opioid crisis without providing the appropriate treatment and essentially engaged in substandard practice. Now, I'm going to just sort of quickly go through what these medications are, what they do. I want to save time for how to bring these medications into practice. Broadly speaking, there are 3 medications approved by the Food and Drug Administration to treat opioid use disorders. Methadone, Methadone is referred to as a faux agonist. An agonist means that when it attaches to nerve cells in the brain, it stimulates those nerve cells. It causes them to fire, particularly what are called the mu-opioid receptors in the limbic system of the brain. It is a dysfunction in this part of the brain that is responsible for the disease that we refer to as addiction or dependence. Methadone will bind to these receptors and generally do so preferentially. As a result, they basically occupy the receptors and block the effects of other illicit opioids such as heroin, fentanyl, and the like. Because they stimulate those receptors, they reduce withdrawal, which is severe feelings of sickness and pain and discomfort when people have low levels of dopamine in their system, and also alleviates cravings for the drug. Individuals who have opioid use disorders or alcohol use disorders feel essentially obsessed and compelled with getting the drug. There's a tremendous tension, stress response, and they need the drug. And so between withdrawal and cravings, those are among the biggest predictors of relapse and treatment failure. By stimulating the receptors, they reduce that, but the stimulation is gradual, it's slow acting, and it's sustained over time. So individuals who are tolerant to the medication, and methadone elicits rapid tolerance, they will not be intoxicated when they take the medication. They will not be sedated. And in fact, if somebody is sedated or intoxicated from it, that would be an indication either that they've been dosed too high or too quickly, or perhaps that the person is not fully tolerant to the medication. Because methadone is itself an opioid, it does cause physiological dependence. For somebody who is not tolerant to the medication, it can be intoxicating, and also it can cause serious side effects, including respiratory suppression, which could, in extreme cases, lead to overdose and death. Most of those side effects occur when methadone is being used to treat pain in private physician practices, and usually not when being used to treat opioid dependence. Most side effects will occur, if they occur at all, within the first 2 weeks. And so once somebody has been properly titrated to an effective blockade dose of methadone, the odds of overdose and other adverse events are lower than for people not receiving the medication. Methadone must be dispensed from a federally state-licensed, regulated opioid treatment program when it is being used to treat addiction. When it's being used to treat other disorders such as pain, it can be dispensed outside of such clinics. Individuals can get take-home doses after they have achieved certain legal benchmarks for stability and abstinence. Naltrexone is referred to as an antagonist. An antagonist attaches to the same receptors in the brain that methadone does, but it does not stimulate those receptors. It essentially blocks them, sits on them, but does not stimulate the receptors. It is most commonly known as Revia or Dipade when it's administered orally. Many of you will be familiar with it under the name Vivitrol, which is a approximately monthly injection as opposed to a daily pill form. Because naltrexone does not stimulate the receptors, it does not cause intoxication or addiction. It also has no effect on withdrawal. And in fact, if somebody is not fully detoxified from opioids before taking naltrexone, it will cause very often a severe and precipitous withdrawal. The oral version of naltrexone does not appear to alleviate cravings for opioids, but the injectable version has been shown to alleviate cravings in studies, not studies conducted in the criminal justice system, but studies conducted in other treatment settings. So it appears that it may have anti-craving effects. The side effects, unlike methadone, where the side effects can be severe, are generally relatively minimal side effects, assuming the person has no problems with liver functioning and the like. The biggest side effects tend to be injection site pain and the like. And there is no special waivers or licensure required. Any licensed practitioner medical practitioner can administer naltrexone. Now, naltrexone is a full blockade for opioids. Vivitrol is also FDA approved for treatment of alcohol dependence. Although it does not provide a complete blockade against alcohol, it has been shown, especially with people with certain genetic alleles, to reduce craving for alcohol, to reduce the time period if somebody begins to use, to reduce the length and severity of relapse. And so it is an approved medication for alcohol use. Buprenorphine is referred to as a partial agonist or a mixed agonist antagonist. Essentially, it is an opioid, but it has a much lower ceiling of effects. And by ceiling, we mean that, there's usually the more dose of a medication you get, the greater the effects. When you hit a ceiling, you're essentially saying that you've hit the top of the dose response curve, and greater dose does not lead to greater effects and or side effects. As a result of that, the likelihood of intoxication and dangerous side effects is greatly reduced, and the severity of it is substantially lower than it would be for methadone. Buprenorphine is commonly marketed under the terms for the medications I'm blanking on, the manufacturer term. Subutex, Zubsolv, Butrans. There's an injectable version, Sublocade, and there's an implant version that lasts about 6 months known as Probufene. Many of you may be familiar with it as Suboxone. Suboxone is buprenorphine mixed with naloxone. Naloxone is actually very similar to naltrexone. It is an antagonist, but it's much shorter acting. And so if somebody has opioids on board and the naloxone is released, it will sweep the opiates off the receptors and cause a swift withdrawal, a severe withdrawal. By combining Suboxone with the naloxone, as long as people take the medication as they're supposed to, usually under the tongue or by the cheek, dissolve gradually, the naloxone is inert, has no effect. But if somebody were to attempt to inject the medication to achieve an intoxicating effect, the naloxone would be released and cause withdrawal. And so the naloxone is put in buprenorphine as a way to avoid misuse. It's essentially an abuse deterrence formulation, which is shown to be effective. Like methadone, buprenorphine binds preferentially to the cells, so it will generally get there first and will blockade illicit opioids, mostly like heroin, fentanyl, and the like. Less likely to cause serious side effects. Like methadone, it alleviates withdrawal symptoms and cravings. The effects are gradual, slow-acting, and sustained. It elicits rapid tolerance, so it works in reducing withdrawal and cravings as methadone does. Although you do not need to get buprenorphine in a federally regulated treatment program, physicians, nurse practitioners, physicians' assistants need to go through a training course, physicians 8 hours, nurse practitioners and physician assistants 24 hours in order to be waivered under the Drug Abuse Treatment Act, the DATA Act, to prescribe buprenorphine, and then can do so from private practices, physician practices. I'm not sure what's happening here with the slides. Okay, I see what I did. Sorry, everybody. Okay. In terms of effectiveness, as John mentioned earlier, we just completed a resource guide looking at the research on these medications and their effectiveness. You're looking at a chart here of the 3 medications, methadone, buprenorphine, and the extended release version of naltrexone, the Vivitrol, looking at their demonstrated effects on various outcomes. Green checks mean that the effects of that medication have been proven in randomized controlled trials, meta-analyses, systematic reviews in the criminal justice system. So they've been shown to work with criminal justice populations. The red checks means that they have been shown in experimental studies outside of the criminal justice system, so in general physician practices or in the opioid treatment programs, and we have pretty good reason to think the effects would be comparable in the criminal justice system but not proven. If there's no check there, that means that the effect is either not proven or has not been studied sufficiently. And so you can see that methadone and buprenorphine have undeniable effects on withdrawal symptoms and cravings. The extended release naltrexone appears to have effects on cravings, although most of that research has been outside the justice system. Both methadone and buprenorphine improve treatment entry and retention for individuals in the criminal justice system with opioid use disorders. When it comes to actually reducing illicit opioid use, all three medications are undeniably proven to reduce opioid use in criminal justice and non-criminal justice populations. Effects on criminal recidivism have been a little bit less clear. We know that the longer people stay on these medications, the less criminal activity they engage in, but that kind of a correlation does not necessarily prove causality, and so we really need more research to understand what the effects are on crime. But there are other interventions that should be delivered in addition to medications like criminal thinking interventions and other counseling interventions that could address the criminal recidivism. Overdose risk, again, the proportions of individuals overdosing when they're receiving these medications is substantially reduced. And there's some evidence that they also may reduce other health risk behaviors like syringe sharing and even unprotected sex with multiple sex partners. When people are less intoxicated, they're able to engage in more self-corrective, self-preservation behaviors. So what do we know about opioid use disorders in drug courts? We know that about 15 to 30% of drug court participants have a diagnosed opioid use disorder. Our best research recently suggests that participants with opioid use disorders are 80% less likely to succeed in drug court. And of those people with opioid use disorders, less than half in drug courts are receiving any form of medication-assisted treatment. About half of drug courts are requiring individuals to discontinue methadone or buprenorphine within 30 days. In some studies where millions of dollars have been pumped into drug courts to increase use of medication-assisted treatment, between 2/3 and 4/5 of individuals in those drug courts were receiving naltrexone and not receiving methadone or buprenorphine despite any apparent medical justification for choosing one medication over another. And most of greatest concern is a recent study, a 15-year follow-up of a drug court in Baltimore, one of the earliest drug courts studied, in which they found that 23% of participants with opioid use disorders died in an average of 5 years after leaving that drug court. And in fact, the overdose death rates were higher for the drug courts than for individuals randomly assigned to criminal justice processing as usual. It was not statistically significant, but if anything, the drug court's resistance to using medications may have actually contributed to a few percentage points increases in opioid-related deaths. Only about 7% of participants in those drug courts receive medication. Drug court best practice standards from the National Association of Drug Court Professionals say quite clearly that the standard of care in drug court requires drug courts to learn the facts about MAT, that blanket prohibitions are for entry or graduation are a violation of the standard of care. Denying somebody entry to a drug court because they're on any form of MAT or requiring people to get off as a condition of graduation not only violates federal grant funding prohibitions, but also violates the standard of care for drug courts. And in fact, some recent cases have even said that jails and prisons with blanket prohibitions may be violating the Americans with Disabilities Act or the Eighth Amendment to the Constitution by denying medications without a particularized reason in an individual case. Drug court professionals are required to decide to make a particularized inquiry based on medical indication or necessity in each case. Why does this person need or not need medication? That information should come from treating physicians, not from criminal justice staff. The judge is required to say on the record why he or she is denying medication or requiring a certain kind of medication. The purpose of having it be said on the record is so that an appellate court can review that judge's decision and decide whether it was rational, which is the test they're required in drug court, and whether it was a violation potentially of participants' due process rights. Drug courts are to receive medical consultation where available. a couple of best practices, and I'm going to let the experts in drug courts programs actually speak more. I want to say a few things about some of the best practices in drug courts. Many criminal justice programs say that you cannot receive medication-assisted treatment unless you are already engaged in psychosocial services, counseling, and that if somebody is not engaged in counseling, they cannot receive MAT. In many programs, if people are not engaged, not showing up for psychosocial services, they are taken off MAT essentially as a sanction or response to failure to engage in psychosocial counseling. The research suggests that the exact opposite of what ought to be happening, that in the early stages of treatment when individuals are experiencing cravings, withdrawal, they're clinically unstable, the most important thing is to get them stabilized, and that medication-assisted treatment gets the person stabilized sufficiently so that they can take advantage of and make use of counseling services. And so requiring counseling before MAT is to put the cart before the horse. The most important thing is stabilization of the case and then introduction of psychosocial services as the person is becoming clinically stable. Research is unambiguous that anytime you take somebody off a medication that has been working, you reduce the effectiveness of that medication if it's reinstated. You reduce the chances that the person will accept and resume treatment in the future. And you can also cause other serious medical consequences. For example, taking people off methadone or buprenorphine lowers their tolerance. If they are then released to the community from drug court or probation or jail or prison and their tolerance is low and they go back to drug use, they are at increased risk of overdose and overdose-related death. So forced withdrawal from medications is absolutely contrary to the standard of care, even though it is well-known practice. Changing medications, even if you change somebody from one medication proven to work to another medication proven to work, taking somebody off a medication that is already working interferes with treatment effectiveness. That's why physicians are very loath to change a medication when it's working, even if some newer medication becomes available, unless there's some problems with side effects. So taking people off methadone or buprenorphine to put them on naltrexone is clinically contraindicated. It is exactly the wrong practice. Many limits on dosage and duration in jails, prisons, drug courts are illogical and undermine the standard of care. Average doses in many programs are between 30, 50, sometimes 60 milligrams a day for periods usually no more than 90 days. Research establishes that medication-assisted treatment with methadone under 60 milligrams has no effect whatsoever, and under 90 days has no effect unless you are engaged in a medical withdrawal. And so many programs have limits on dosage or duration that prevent the medication from working. It is important, though, to have individuals supervised by community officers. Probation, parole officers have a role in ensuring that the person is going to treatment, in maybe engaged in monitoring medication compliance, doing pill counts, having the person take the medication under the direct observation of clinical or criminal justice staff to avoid diversion. And it is critically important for drug courts when they send people to self-help groups, recovery groups, that they send them to programs that are supportive of or at least not disapproving of medication-assisted treatment, because sending somebody on an MAT regimen to a recovery group that is disapproving of MAT generally undermines treatment adherence and lowers individuals' motivation for change and confidence in their ability to improve. I am now going to pass the computer over to my friend and colleague Steve Hansen to talk about ways to get medication-assisted treatment increased in drug courts.
Thanks, Doug. I'm going to talk a little bit about some of the things that have been done in New York State to try and address this issue. And a couple of the issues were the drug courts were frequently requiring participants to stop the medication-assisted treatment either in order to participate or graduate. And we frequently had treatment providers who did not support MAT. The history of addiction treatment, we've had a lot of people who have come up through traditional 12-step methods and have gotten into counseling, and there was a bias against methadone and some of the newer MATs, particularly when they were referred to as not real recovery. What was changing was, as a result of the opioid crisis, that courts were seeing significant numbers of fatalities among their participants. Treatment providers were also seeing fatalities, and frankly, almost everybody was seeing fatalities. It's hard to find a group of people who have not been impacted either by a relative, a neighbor, seeing something in the news, somebody local that they know of that has been impacted with a fatal overdose. So in terms of this, our agency, the Office of Alcoholism and Substance Abuse, with a lot of support from the Office of Court Administration, shout out to Kim, I know she's on the line, and we've been providing education for judges, court team providers, outlining a lot of the stuff that Dr. Marlowe did, that MAT is the standard of care, and really emphasizing that MAT is a medical decision, not a judicial one, that a judge determining which medications you could be on or not is the judge acting outside of their practice and practicing medicine without a license. Most judges seem to respond a bit to that logic. We also were able to get legislation from our legislators and signed by our governor, which prohibited requiring the cessation of MAT to either participate or graduate from a drug court. So right now, almost all of the drug treatment courts have accepted MAT. Occasionally, we get an outlier. Frequently, there's a new judge appointed to the role who hasn't had the training or the experience to understand that, and we work with the Office of Court Administration to try and address that and let them know in specific what the regulation is about not allowing that. Non-problem solving courts still had issues, and we still continue to work with further education for those courts, and those include criminal courts, family courts, juvenile courts, et cetera. Now, some of the issues that we were seeing, opioid use and risk of fatality is fairly widespread. Individuals whose crime does not meet the criteria for a drug treatment court were not provided access to treatment through the criminal justice system, and that for those who did meet the criteria, they were dying of drug poisoning deaths between arrest and enrollment in treatment. So our focus has been in the state to engage in treatment, including MAT, immediately. And when we say immediately, it's now, right now, not we can get you an appointment a week from Tuesday. So this basically follows the sequential intercept model where we see intervention strategies at different points of contact in the system. And what we're trying to do is make assessment referral immediately available, even 24/7, and use peer supports to help engage. So as the chart shows, there are community services where people can get engaged, and then when the criminal justice gets involved, Intercept 1, we'll talk about a model where police officers can do it at the point of arrest. Intercept 2, where there's initial court hearings. 3, going into specialty courts. 4, what happens on reentry, and then community corrections. So they cover these basic areas, and one is talking about the difference between folks who get taken into custody and what in New York is known as an appearance ticket. You're arrested, the officer gives you a ticket and says, please appear in court on the following date. Through the arraignment process, the plea agreement, if you go into a court case, that disposition, sentence, and incarceration or supervision. So one of the models is the heroin overdose prevention and education program, the HOPE program, which was started by the Staten Island District Attorney, and that's Mike McMahon. And his idea was that the police officers at the point of arrest were frequently finding people who had what would be a minor possession charge. If the officers even wanted to pursue it, they would be giving a desk appearance ticket, and then they would walk away from them. Now the police consult with the district attorney's office just to make sure there are no other outstanding warrants or other reason not to include somebody, And if the person is eligible, and the vast majority are, they're taken to what we have in New York called open access centers, and these are 24/7 programs. They're not beds. They're basically a waiting room of sorts where somebody can go in, they can meet with peers, they can get immediate referrals to treatment, and usually you stay in there as a way to keep safe, and then by the next morning we've got you engaged in a treatment program, including MAT. And then if the individual stays active in the treatment for 2 months, the charges are dropped. So you have that there's a benefit to the person. So other counties like Monroe in the Rochester area in New York have adopted this model and implemented it. In the Bronx, Judge Grasso started the Overdose Avoidance and Recovery, or OAR program, and this was for folks who had minor charges. They didn't get a desk appearance ticket. They were held in custody and then came into arraignment. And if they identify that there's particularly an opioid problem, there's a community agency that is at the court every day, and they provide case management, referral, and monitoring services. The folks are referred to treatment. And again, if you participate in treatment for a specified time, the charges are dropped. And the judge's comment to me is, we're just trying to get them to treatment's door. Hopefully they'll walk in and you guys would be able to do a great job with them. But we are tired of not being able to do anything, so at least get them into the treatment program. The Buffalo opioid court model was a little bit more involved. And it was sprung out of the fact that their regular drug treatment court was losing in participants prior to enrollment. So somebody would get arrested. It would look like they could be in the drug treatment program. It would take usually 8 weeks to get engaged. And sometimes, within that 8 weeks, a parent would notify the court that their child had died, usually a young adult in their 20s or 30s. And they wanted to address that. So what happens is that all people who are incarcerated are screened for OUD issues. It's a very brief 4-question screening. Are you using opioids? Have you ever overdosed? Have you ever been given Narcan? You appear in front of a judge in the morning right away. And what you start with is a 30-day program where you appear in court daily. That's business days, Monday through Friday. It's actually a 90-day long program with less intense appearances in the court on days 30 through 90. And again, they have immediate assessment and enrollment in treatment. They have staff from treatment programs who are in the building. So the judge will say, okay, go downstairs into room 202 and you'll meet with somebody. So they'll get an instant assessment. The staff members are connected by internet to their home office computer systems so they can enter into electronic health records. And we also have a mobile van unit that is parked outside mornings of the court that provides access to buprenorphine. For those who need transportation to treatment programs like detox or inpatient, we have an agency called Save the Michaels of the World who will provide that transportation and some peer support. Save the Michaels was founded by a couple who lost their son to complications. He has suicide as well as opioid use disorder, and they are very invested in trying to make sure that this doesn't happen to anybody else. We also have the 12 addiction treatment centers that are accessed statewide, and we've set up sort of a network with relays for transportation that we can take somebody from one corner of the state and get them to the other fairly quickly for that. The state has decided that they're going to open up 13 new opioid courts. These were identified by the Office of Court Administration. And we're partnering with those courts and through our SOR grant providing the counties or the courts that are running that with $150,000 each to provide on-site clinical and peer services. It's expensive for clinical services to be there, particularly if they're not getting any customers, they're not generating revenue to cover their costs. So we're sort of giving them a starter that they can start going, and if they can still bill for services if they are able to, particularly since New York now has for substance abuse outpatient services an in-locality element, where as long as you work for a licensed agency, you can go to various places like courts or schools, provide that service, and your agency is able to bill for it. Matt, and corrections, this has been a major movement in recent years. Rikers Island has been doing this for over 35 years. They're one of the longest running in the world in terms of providing methadone and buprenorphine. The first run through is we trained in the state almost everybody who is working at a jail or incarcerated at a jail on naloxone or Narcan. Most of them are provided with kits that they get when they are released. Injectable naltrexone or Vivitrol, there's about 43 counties in New York who now have an active Vivitrol program. This is the one where Alkermes will provide one free dose to be administered just prior to somebody's release, which gives them about a 30-day window for some safety. As research has noted that the first month after release from incarceration, you have a 12 times greater risk of mortality than the regular population. And others are moving into methadone and buprenorphine. As I mentioned, the injection provides 28 days on the Vivitrol, and we had 44 as of today. We also have 4 state correctional facilities that are doing that. Methadone in corrections is complicated. An opioid treatment program is the only entity that's allowed to prescribe methadone for opioid use disorders. So what we have been working on is providing partnerships where the correctional facility provides psychosocial counseling and medical health care, and the OTP provides the medication. The OTP consults with the correctional facility medical staff regarding dosage issues, and we've been able to get a waiver of some of the regulatory requirements for the OTP. They sign an agreement with the correctional facility who will provide those services on their behalf. And then the process is that the correctional staff go and pick up what are called take-home doses from the facility, from the OTP, for all the patients in the facility who need methadone. For a while, we were transporting every patient every day. That was very ineffective, as well as creating great risk for folks absconding, bringing back contraband, and other issues. So now with the inmates staying in the facility and the officers going to pick up the medication in an appropriate manner has been much more effective. So here's some of the jails: Albany County, Monroe County, Nassau, and Suffolk. Nassau and Suffolk are on Long Island. And we have at least 5 others that are either started last week or getting ready to start in the next couple of weeks. And this, again, is going to be driven particularly as court rulings are requiring that jails provide access to the standard of care for the illnesses that the inmates have, and opioid use disorder being the illness, and methadone and buprenorphine essentially being the standard of care for that. Buprenorphine in corrections is complicated, mainly because it's the major contraband in many jails and prisons. So there's lots of concerns over diversion. We've been providing training on MAT, particularly on buprenorphine. One of the problems that we're running into is that while the person is incarcerated, we can get them access to the medication, but when they're released, not having enough prescribers who have the data waiver and are actually also prescribing the medication. There are various observation protocols to prevent diversion. We thank Rhode Island who let us come visit, and we saw some of the methods that they do to make sure that people aren't diverting the buprenorphine in the prison. And again, that buprenorphine, New York is a big state with lots of very rural and frontier areas, much to many people's surprise, where there's not an OTP nearby. So if there's not an OTP nearby, just providing the methadone will be very impractical when they're released. So buprenorphine is available for those who don't live near an OTP. And that's it for me. And I'm going to pass the magic ball on to the commissioner. There it goes.
Hello. So in the city of St. Louis, what we noticed was a trend that was taking place, an upward trend on mortalities and fatalities based on our opioids. What we had looked at were the numbers and what we saw between 2009 and 2011 was a huge spike, double the amount almost. We began working with our community partners, a corporation, Alchemies was mentioned earlier, some of our treatment facilities that were licensed to provide MAT services, and began an opioid track in 2012. So based on this information, we were able to, at that time, have particular probation officers and treatment facilities trained in medically assisted treatment, being on this particular one day a week docket, and working with our population. We wanted to be able to have targeted, intensive case management. We knew that we would need to do specialized testing for these particular participants. We knew that we would need to continue to have ongoing education with our probation officer, our commissioners, and our treatment team. So that was beneficial to have all of these persons on one particular docket receiving these centralized services. At that time, the participants were receiving either methadone, the buprenorphine, and at that time we worked with Alchemies for our participants to receive naltrexone. As mentioned in one of the earlier slides, we were able to work with this corporation once the participants were identified that remained incarcerated, working with the the medical unit and our minimum security institutions to have blood work drawn, to talk with them about if they wanted to receive naltrexone in the injection form, and educate them if they accepted this. If they accepted that they wanted to receive this, then they were able to receive this before being released from the institution and beginning the program. We saw that this was beneficial where they were at least not overdosing before they could enter the program. For those who did decline to receive naltrexone in the injectable form, we were able to gather their information and either route them to methadone clinics or the facilities that at that time were providing buprenorphine. As our docket continued, both commissioners were trained. We increased our treatment team, which also received medically assisted recovery certificates. We also provided this training for our probation officers. And then we noted that as our population began to expand, we needed to leave time and energy and resources to continue to train our team and provide education for every team member. We were able, and we benefited from the fact that the Department of Mental Health allowed us to contract with the different agencies to bill for medications. As I noted, we had a corporate sponsor who provided naltrexone at no cost to individuals while they remain confined. It gave us the window of the 28 days to get them connected with agencies in the community. So once they were released, we began the time clock on getting them connected with not just treatment, but continuing to develop some stabilization in the community. Our other agencies were able to tap into the resources and use federal grants and any other funding that was available at that time. So as we continue to grow, this population has expanded. We, as of this year, we have increased the docket, so we don't have it on one particular day. We've continued to work with the population and our community partners. One of the challenges that we had then was funding. That continues to be a challenge with us. Funding for any of these services is even more difficult when the participants do not have health insurance. We have partnered with particular agencies that when our participants are released from confinement or if they come into the program on bond, we are able to connect them with agencies so they can begin filling out paperwork for health insurance. Other challenges, the stigma of any medically assisted treatment, as was mentioned with our previous speaker, those who feel that the person does not need medically assisted treatment, and this is somewhat a crutch, as some may say. So we have to continue to educate any counselors, any resources that we encounter, and that includes even our team. If we are hiring new probation officers, we immediately provide information regarding medically assisted treatment, so they're educated on the use, the resources that we have, and any ongoing research that is provided. So what happens when the funding and the grants are depleted? This is where having your community resources available is very important. Keeping conversation going in your community, keeping meetings, and continuing to educate any source of funding. We also are constantly researching any grants that could provide further resources, funding for any of our medically assisted treatment. So the picture of our implementation of 2012, at that time we had a lower population, approximately 220 participants. We were limited, and we had just began working with an agency regarding naltrexone and the injectable, methadone and buprenorphine. As of 2018, we have now approximately, and we're around this number in 2019, 320 participants. Our medically assisted treatment services have increased, where we have worked with agencies to be able to provide more than just the buprenorphine. We are continuing to work with agencies to be able to provide Suboxone on not just a detox few days, but to provide some Suboxone maintenance for those who are requiring it. I urge any courts that are considering implementing a docket to get their community partners involved immediately, get some buy-in from them on what they see could be life-changing and life-saving. And by them being involved at the beginning, there's more buy-in for them to continue to be involved with the treatment courts, provide any support that they can in any way. Before implementing, if you have the resources, educate the entire team. Don't overlook even a probation officer or a treatment counselor or even your courtroom clerk. Everyone should be educated on medically assisted treatment and the benefits. have a designated case manager that's able to make appointments with your community agencies, that is able to follow up with these appointments, that is able to, if there are any challenges that arise for your participants, that are able to assist them. If they learn that they have no transportation to the appointments, be able to assist them with transportation, whether that's bus passes or even cabbing them to these facilities. So having a case manager that is strictly working with this population, if you are able to, is very beneficial. Examine the cost for specialized testing. Be sure to maybe work with what other agencies you have that provide your analysis. See if you can work with them on a reduction of the cost for the testing if they know you're going to have a certain population that you'll need to do that. Don't take that for granted on having specialized testing. Not just your community resources, but also engage your corporate resources to help shoulder some of the finances of the medication. There are other corporations that may begin to assist you if you are engaging if you are implementing an opioid track, so that you may be able to get some corporate resources that would assist you. And as I noted, having someone to work with the participants to get them to sign up for insurance as soon as possible, they may be able to reach some resources provided through funding in the community agencies, and they could provide medically assisted treatment once they have received insurance. So some of the challenges will always be the stigma of MAT services, but I encourage anyone that is considering implementing a docket to take a look at all of the resources that are out there, have a plan of action, and have a team in education on board, and it will be very beneficial. Our population has grown so much that it's exceeded one day, it's exceeded 2 days, but it is worthwhile, and it is so beneficial for the participants that we are working with. You can pull this off, having folks who are able to reach out to the community, have appointments, make appointments, talk with your city leaders. You can pull this off. I wish everyone success. If you have any further questions for me, please let me know. Melissa?
Okay, thank you so much. I want to say thank you to all three of our presenters. We really appreciate this wealth of information you've shared with us. And we do have just a couple of minutes for Q&A. If you have some questions, the Q&A portal is open, and we would love to hear from you all. This is an opportunity for you to get your burning questions answered directly by national experts. So I see there was one question already about reaching out to partners. Stephen and Doug, anything else you would like to add in terms of collaborating with partners or blended funding, or ways to get creative in terms of ensuring that people can access medications through partnerships with different companies or nonprofits or community agencies?
I know one of the questions is about access to Vivitrol, and the manufacturer, Alkermes, will provide coverage. Will provide that initial dose. You just have to reach out to them. They'll contact you with a local rep. And the notion is that because people incarcerated are not eligible for their health insurance, particularly Medicaid, that once they're released, they would have time, if they're Medicaid eligible, to be activated and hopefully your state has included Vivitrol as an approved medication for their Medicaid population, so they would be able to continue it from there.
Any pointers on how to work with other partnering agencies to increase access to the other forms of MAT medications, methadone and buprenorphine?
So this is Doug. Am I unmuted?
Yes.
Yes.
Yeah. So, I think a very important thing to do, if the issue here is reaching out and trying to locate providers, the issue with methadone is that it needs to be distributed by regulated OTPs, and many of them are at or above capacity. They have strict requirements for psychosocial services. In addition, so that they don't just put people on medication while they're waiting for those groups to open and stuff. And so community-based physician practice providers doing buprenorphine waivers is a good way to make connections with providers in the community. And if you were to go on, there are several websites that are listed in the resource guide that John had mentioned. I think there'll be a link to it. The American Academy of Addiction Psychiatry, the American Board of Addiction Medicine, American Society of Addiction Medicine, SAMHSA, they all have websites that you can go on and you put in your zip code, your community, the county you're in, and they give you lists of OTPs, community providers waived for buprenorphine and the like. So if you're trying to kind of beat the bushes to find where people are, there are many locator services. There are also locator services for self-help recovery groups that are open to medication-assisted treatment. So just in terms of kind of beating the bushes and finding people, there are ways to do that.
Also reaching out to all of these partners, having a meeting, letting them see that there are so many agencies that are ready to work with you, and that could encourage them to get involved. Sometimes agencies don't want to be the one not on the list of folks that are doing something new and innovative in your community.
I want to springboard off to what Commissioner Woody has just said, and that is nothing really is as captures the attention of psychiatry and addiction medicine departments in hospitals, practices. If you go to local medical society, when they get a letter from a judge, and we're talking largely about drug courts here, and they get a letter from a judge saying, we have a very large population of people, justice involved, they're in a program in which they're carefully monitored, and we recognize the importance of medication-assisted treatment, we're looking for partnerships, you will get an audience. You will get to go speak at the medical society. You will get to go speak at a hospital grand rounds. Or inviting them to come to the drug court and to observe drug court and to have maybe a brown bag lunch and speak to the staff, the drug court team, maybe even make a presentation on MAT services available. I think that kind of profession-to-profession alliance building is very effective, and a letter from a judge gets people's attention.
Thank you for that. And someone asked, someone commented, my concern is that participants can no longer afford the MAT medication after graduation. Would it not be better for them to discontinue use while receiving the drug court support? And that is a grave reality, particularly in our states that didn't expand Medicaid, and a large majority of their criminal justice involved individuals do not qualify for Medicaid coverage. So across all of our three presenters, any thoughts on how to navigate that while the person is in the drug court and once they transition into the community?
So this is Doug. The standard of care for the treatment of opioid use disorders is medication-assisted treatment. So there's never going to be a justification for delivering below the standard of care, assuming the medication is, kind of reasonably available. If there's no community providers because you're in an extremely rural area, things like that obviously are exceptions. And so if you are in a non-Medicaid expansion state, and if participants cannot be hooked into the private insurance through the insurance exchanges, and if you can't get any kind of third-party reimbursement, then I think there are several avenues, but you're going to have to do some of the things that were mentioned earlier. One is trying to contact pharmaceutical companies directly, but there's also a federal program. I'm kind of blanking on the name of it right now. I think it's the 340B drug discount program, where any drug manufacturer participating in Medicaid, so if you're a Medicaid covered medications, then you are required to make some of those medications available at reduced prices, especially in underserved communities. So the very communities that are least likely to have a competitive insurance market or insurance exchange market, hospitals that serve a disproportionate share of poor, uninsured patients, sole community centers, rural referral centers, those kind of entities are, through federal government programs, required to offer some of these medications at discounted rates. Federally qualified health centers, especially those in inner city and rural environments, will offer buprenorphine at discounted fees for people who are uninsured. Assuming somebody is not Medicaid eligible, they can't get insurance coverage elsewhere, then they become eligible for these sort of stopgap programs. But no one's going to come running to you and tell you that these things exist. You have to go and push the issue. I wouldn't underestimate the point that both Commissioner Woodius and Steve Hansen made about talking to the pharmaceutical companies themselves and seeing if it's possible to negotiate some ways of getting these medications funded. What is not a valid rationale is to say, well, since they may lose funding in the future, we should not provide the medications in the drug court. Our goal is to save lives in the middle of an opioid crisis where success rates without medication are negligible. And so I don't think we can ever err on the side of saying, since it's hard to get, we won't make it part of our regimen.
Commissioner Hansen or Woodius, would you like to add to that?
I think that part of the issue, as Doug points out, is the medical decision about what is the most effective care, and the standard of care for opioid use disorder is the medications. The other issues in terms of what settings, who covers it by insurance, those are policy issues that continue to change day by day in terms of correctional facilities allowing it, drug courts allowing it, and as the epidemic continues, hopefully people will be advocating for their state and local governments to do something to help save the lives in their community.
And just to add to that, reaching out to the corporation sometimes is mutually beneficial if you have a corporation that wants to show that they're working in the community, and they reach out to the treatment courts, such as the corporation that worked with St. Louis City and continues to work with them. For us, it was an opportunity to work with this agency in receiving treatment, and we knew it wouldn't cover all of our opioid population, but those identified through the medical team at our facility was able to take advantage of that. It also made us aware that there were other agencies. As I said, it is difficult, and you have to have, from a practical point of view, you've got to have an administrator or a coordinator or a project manager that is able to continue to pull these resources together, have the big meetings, have the small meetings, have everything in between, and continue to reach on those resources. Memorandums of understanding with some of these agencies is key for us because we were able to receive information if they have concerns that at the end of the fiscal year they're losing funding. They're giving us this information in enough time for us to reach out to maybe some state agencies, some community partners to tell them that we have a shortfall and to reach out and find other resources. Thank you.
Thank you.
If I could address one of the other questions that was typed in as to what makes one MAT preferred over another one.
I was just going to move to that one, so go ahead.
Okay.
Sure.
Like many illnesses, there are several medications for opioid use disorder, just as there are several types of medications for diabetes, for high blood pressure, headaches, depression, etc. And medical practitioners have a variety of things that they rely on in order to make their decision about what medication. There are some like access issues, particularly around access to methadone. If you're not near an OTP program, where you would have to be able to go there every day to get your medication, so buprenorphine might be the choice. You might take a look at somebody's history, their experience with other medications, and like what the safety profile does. Does somebody need a lot of structure in their life? Methadone programs are good at providing some structure. If they have a job, if they have been using for quote-unquote a shorter period of time, then you might look at buprenorphine or Vivitrol. One of the concerns about Vivitrol is we're not sure if it's exactly due just to person's preference or to cost effects, but we do know that the number of people who come back for their second or third dose is not where we would want it to be in terms of this medication being used for like an effective amount of time. And if you don't take the medication, it's certainly not going to work. So there's a variety of things that you look at. If the medication is being diverted in the setting, like in a jail, then jails are implementing practices to try and cut down on that amount of diversion. That's not really the medical issue. If you have patients who have known histories of diverting their medication, then that impacts the medical decision about what to do.
Thank you for that. Commissioner Woodiest or Dr. Marlowe, would you have more you would like to add to that in regards to that comment?
Just springboarding off Steve's last point about choice of medications. I mean, one of the one very important predictor of success on medication is past success on that medication. And so to the extent that jails or prisons or drug courts have policies in which they say, okay, we will allow you to use MAT, but we will only allow, and they'll pick a particular medication for whatever reason, and individuals are required to move from one medication to another based on some policy, decision that's not based on the facts of that case, is an exceptionally destructive practice. And the reason I point that out is because it's a very common practice to move people from one medication to another against their will, because that's our policy. And that is not just ineffective and undermines treatment success, but in some cases, especially when you're moving people who have been maintained on agonists like buprenorphine or methadone and putting them into either a forced antagonist like naltrexone or whatever, is that you may very well be reducing tolerance in an unstable case, and that is what leads to death. When people are released from prisons, released from programs where they're being carefully monitored and they've been moved to an antagonist medication against their will, against their preference, and then they leave treatment and they are at risk. Sometimes the risks for overdose death in our populations are anywhere from 40 to, some studies even said, 100 times higher. And that's just unacceptable. So this choice of our policy is to follow a particular medication is not just medically unjustified, it is medically dangerous, and it has to stop.
Thank you for that. Commissioner Woodiest, do you have anything else you would like to add?
I'll refer to the point made earlier of it's very important that the judge nor the probation officer nor the treatment counselor direct the participant to particular medically assisted treatment. It's important to have several facilities, not just providing methadone or Subutex or buprenorphine, but also if you have someone that is providing naltrexone, and for the individual to meet with the doctor. I've stressed that a lot. Sometimes participants believe they should try this because someone said it would be important, it would be better, and they really have to have that conversation with their doctor and make the right and the best decision for themselves.
Thank you for that. And I think that plays well into the next question I have, where someone said, we operate MAT here in Santa Fe, and one of the issues we encounter is differing philosophies, prescribing philosophies among their community providers. And so the commenter provided some examples of those differences. How would you all advise that drug courts work with the various community providers that may have different perspectives in terms of prescribing?
Can you said there were examples. I'm not really sure I understand the question. So what are those differing prescribing? You mean some are against MAT, or they just use different doses, or what
It looks like they provide different dosages. So, for example, one provider supports prescribing up to 16 milligrams of Suboxone. Other providers prescribe up to 3 strips of the 8-2 film. So it looks like they have different perspectives in terms of dosage related to prescriptions. Does that make sense?
Dosage issues, the dose numbers you're giving are not outside the ballpark of, sort of common recommended amounts. So between 8 to 16 milligrams for buprenorphine, or between 60 and even as much as 100 or even more milligrams of methadone, that is within the ballpark of what evidence suggests are effective doses. How they're selected in an individual case, the important issue is that physicians be inducing or, putting somebody onto a methadone or buprenorphine regimen, gradually through in an incremental way, and that they are only increasing the dose when the person appears tolerant, no sedation, no intoxication. And so if that protocol is being followed, then the numbers are not the issue. Now, what's implicit in that question is that there are some programs where the participants seem to be, they're coming to drug court and they're nodding out in the groups, and they're seeming disinhibited, and they're seeming, sedated, and the program, is not responding to that. Then I think that's a question about the quality of care, and then that's why, as the commissioner and both commissioners said, you need to have several programs to choose from to make sure that your patients are doing well clinically from the program. I wouldn't be focusing on the numbers that much. Anybody disagree with that, Steve or Commissioner?
Yeah, the dosage ranges can be kind of like a various thing, but they are within the normal range. You just need to just know what your providers are doing, ask some of the questions. Do you think that the person might be taking half their medication and diverting the rest? And talk with their prescriber around what the concerns are.
I agree. I think also it would be important when you are meeting with these different agencies to get a full understanding of their methods and their procedures, and that would help you avoid any agency that has some strict deadline, hard line on what they will provide, and it's arbitrary. It's not based off of any best practices. It's not based off of any studies. It may be based off of just what their director said we will do. I don't think that happens a lot, but everyone should be are on the same page as far as how they're prescribing and working with the person individually and what's best for them.
Thank you for that. And I think in line with that question, there are a lot of questions about dosage. People also ask about tapering individuals off of MAT. And so could any of you explain how your perspectives on whether or not an individual should be on MAT long-term, and how are those decisions made?
Those decisions are made by the patient and the physician that's prescribing the medication. There's no other instance where the legal system gets involved in determining how long you should be on insulin, how long you should be on an antidepressant. That's a question for the doctor and the person. Some people will need to be on MAT for a long, long time, perhaps the rest of their life, based on their medical condition, their history, the risk of overdose, et cetera. Some may be able to be on in a short time, but that question is really not relevant to what the criminal justice involvement is. The focus is on how do we get people the care that they need right away, so we have the best chance of them surviving and the best chance of them engaging and doing well in the rest of their life in the community.
This is Doug. I would second what Steve said. I think if you read the Surgeon General's most recent report, Spotlight, on the opioid crisis, the Surgeon General concluded that on average, and this is an average, successful methadone and buprenorphine regimens generally last about 3 years, minimum of 3 years. So programs that are telling people to get off in 90 days, drug courts that are saying you have to get off before you graduate in 12 to 18 months are simply engaged in illogical, ineffective practice. This is, if somebody's had an early age onset of opioid use, long-term use, if there's a strong family history, if there's a co-occurring psychiatric disorder, these things tend to predict better outcomes with longer maintenance regimens, and other factors predict better outcomes with an earlier taper. And so, again, as Steve said, these are clinical decisions, and they're not just willy-nilly. They're not random. They're based on a series of factors that are scientifically shown to matter. And so, having an across-the-board policy about tapering is contrary to medical practice.
I think one of the biggest issues is that there's so much stigma about the use of methadone. I was in a meeting the other day where people said, well, we got to get them so that they're not zombies. People who are on the correct dose and have been for years are in your neighborhood. You just don't know that they're on methadone. You can't tell the difference between somebody who is at the proper dose and has been maintained for a long time. They can go to work, they can go to school, they can take care of their children, they can drive vehicles, they can do anything that anybody else would do, except they are taking this medication. So there should not be a real, well, how long do they have to stay on it? Why don't we start tapering them before they leave? Won't that be better? The answer is no. They need to be on the medication as long as they need to be on the medication.
And if you start a taper prematurely before the person's clinically stable, you will not only undermine the success of the current regimen, but make it much harder to get that person back up to a therapeutic dose and compliant with treatment in the future. So you really turn people off to treatment when you start messing with regimens without any clinical reason for doing so.
Thank you both for that. Commissioner Woodiest, any additions to their comments?
No, I think they both said what was necessary, thank you, and what was pertinent to the question.
Sure. So someone else asked, are there any specialty courts that have trained participants in the use of naloxone or Narcan, and do they provide Narcan to their participants? So commissioners, do either of your programs do this, or across all of our presenters, are you aware of any programs doing this that are effective?
So this is Commissioner Williams with St. Louis City. We've had someone to come in and they've trained the probation officers. They've also trained the employees at the Medium Security Institute, but we have not trained our participants. And that's still where we run into. This is a courthouse and some of the legalities that the circuit at this point won't address. But probation and parole has trained their officers. They are available if any of the participants comes into their offices and they seem to have some problems. But we have not at this point provided that training for our participants.
We have NADCP, we're putting together a national survey right now to find out exactly what percentage of drug courts do that. But based on some of our sort of preliminary piloting, I think based on what the Commissioner was just kind of alluding to is that when you say does the drug court provide naloxone or Narcan, it's relatively infrequent that that's being provided by the court or at the courthouse or by the probation department. That does happen. What's more likely to happen is that the treatment programs that are affiliated with the drug court and providing service to the clients are the ones that are delivering, groups in, psychoeducational groups on how to use naloxone. What we found is that just telling them about it's not enough. There's some studies in New York State that you really have to help. You have to show them how to use the applicators, the intranasal applicators, to get them to really feel like they really could do this if the time came. And then when they feel like they really get it, so you're not just telling them about the issue, but you're really showing them how you exactly what you would do if a loved one were overdosing. It does appear to help. But what percentage of drug courts doing it, I don't know. We are trying to find out. But if somebody was interested in it and wanted to find a program so that they could talk to them about what they do and how they do it, if you contact the National Drug Court Institute, we could certainly put you in touch with individual drug courts that are doing that.
And as Doug mentioned, I think in New York, almost every provider we have is providing Narcan to their patients.
All right, thank you so much. All right, so we are at the end of our time for questions. We covered almost all of them. So if you do have any further questions at the end of this webinar, we'll have the contact information for the Gain Center. You can reach out directly to us, and we can run your questions by our presenters here. We do have some downloads coming up. The 2 documents that John Berg mentioned during his opening remarks are available for direct download, as well as a fact sheet from the National Drug Court Institute with more information. And so you should see a file transfer box pop up on your screen. You should also see 3 file names. So what you'll want to do is click on the file name of the document you would like to download. Once you click it, it should turn blue, and then the download button should turn a darker shade of gray. So then you'll click the download button, and that will allow you to save that document directly to your computer. If you are uncomfortable downloading files directly to your computer, all 3 resources are available online. You can find the National Drug Court Institute fact sheet on their website. You can find the 2 SAMHSA publications on the SAMHSA store. Just search for SAMHSA store, and then once you pull that site up, search for the title of these documents, and then you can find another link to download those products if you're uncomfortable using the file transfer box. We also have the certificate of attendance available. That now has popped up in the file transfer box. Again, this is only for personal use. We do not provide CEU credits, but some of you have been able to get CEU credits through various organizations. So this certificate is available for your personal use. As I mentioned at the beginning of the webinar, the slides will be sent out via our Gains listserv. If you have not signed up, here is a link so that you can do so. And we will also notify you when a recorded version of this webinar is available on the SAMHSA YouTube channel. And finally, I just want to, again, extend a warm thank you to our three presenters. We really appreciate the valuable information that you have shared with us and the field. If any of you listening have further questions, the contact information for the Gain Center is available here. Feel free to call us directly. We are available to provide phone-based technical assistance and are happy to do so. Thank you so much for joining us, and we look forward to seeing you next time.
Thank you.
Thank you.
Thank you.